The Supreme Court decision in the Voting Rights Act, did it besmirch that most sacred right in our democracy?
All of the protections that people think of when they think of the Voting Rights Act, guaranteeing access to the ballot, prohibiting discrimination, they remain intact. Nothing that was illegal yesterday is legal today.
We still struggle with discrimination and things like voter ID laws that just put on unnecessary barriers for not only Latino voters, but everybody to stop them from an easiest path to voting in every election.
What the Supreme Court did and its implications for voting in our state. It's Arizona Week.
Production of Arizona Week is made possible in parts by a grant from the Stonewall Foundation and by the members of Arizona Public Media. Thank you for your continued support.
Once again, your moderator, Michael Chihak.
Arizona is among 9 states affected by the Supreme Court's 5-4 ruling striking down part of the Voting Rights Act. The decision frees the state from having to submit electoral changes to the federal government for approval. We'll look at what it will mean in state politics. First, elections law expert and attorney Joe Kanefield explains the court's decision. Could you briefly explain the constitutional background to the Voting Rights Act decision of the Supreme Court this week?
Sure. The Voting Rights Act was passed by Congress in 1965 to respond to what was horrific discrimination that had occurred in many states before the act. One of the main requirements of the Voting Rights Act was a coverage formula that required certain states that met the coverage formula because they had low voter turnout or registration and employed a tester device that discriminated against minority voters. So we call that Section 5. And what happened was if a state became covered by that formula, they would have to pre-clear any election law procedure change before it could become effective. And that's done either through the United States Attorney General or through a court action in the District of Columbia, the federal court there. 40 years later, a county in Alabama challenged the constitutionality of Section 5 of the Voting Rights Act, this preclearance requirement, on the grounds that it's no longer necessary, that the harms that it was initially designed to remedy have now been largely remedied for the most part, and that the burden it imposes on the states that are covered under Section 4 and Section 5 of the Voting Rights Act no longer exist, or at least no longer justify this encroachment on state sovereignty. So the United States Supreme Court in its decision this week struck down, in a 5-4 decision, struck down Section 4, the coverage formula of the Voting Rights Act, which means that the states covered, including Arizona, which has been a covered state since 1975, will no longer have to pre-clear their voting laws, their voting changes and procedures, unless Congress revises the formula and ends up covering states like Arizona again.
And the constitutional issues there were the state sovereignty issue that you mentioned?
Yes, and the principal issue, at least the way I read the Chief Justice's opinion on behalf of the court, was that the coverage formula that required these states, only 9 states and certain counties in other states, to pre-clear their election changes, violated what he referred to as the fundamental principle of state sovereignty, of equal sovereignty. In other words, all the states are equal in this nation, and the idea that certain states cannot implement their duly executed laws because of past discrimination, while others can that may engage in similar discrimination or have records that may not be on par with the records in the covered states, but nevertheless they still have had similar bad behavior. That the court found offensive, at least, and no longer justified under the current scheme. One of the things that the court cited to was the fact that the voter registration and participation, which is measured by turnout rates in some of these covered states, is equal to or greater than for the minority population than it is for the non-minority population. And that's a great accomplishment compared to what those numbers were in 1965 when Congress enacted the Voting Rights Act.
A good bit of the law is still intact, right? People are still protected if discriminated against when trying to exercise their right to vote.
Yes, that's a very important point. The Voting Rights Act was enacted under the authority of the 15th Amendment. The 15th Amendment was one of the post-Civil War amendments designed to remedy past discrimination against African Americans and also anyone, any race or color for that matter. Section 2 of the Voting Rights Act enables anyone to bring a lawsuit challenging discrimination on the basis of race or color or a language deficiency. And that cause of action still exists. It can still be brought. It just means that if someone believes that a state, a locality, municipality, a county is discriminating against an individual or group based on their color, their ethnicity, their language, then they have to bring a lawsuit and prove in federal court that they have been discriminated against and there has been a violation.
Is there any significance from a constitutional point of view in the fact that it was a 5-4 decision, in other words, a split court?
No, the way it works, a 5-4 decision is a binding decision of the United States Supreme Court.
Same as a 9-0.
Same as a 9-0.
So what do you say to those skeptics or perhaps cynics out there who say, well, this was just the typical conservative-liberal divide on the court?
Well, I certainly understand their concern because no one can argue that the Voting Rights Act hasn't been successful in providing a remedy for past discrimination. I suppose the argument that they offer is that we're still not quite there and that imposing this burden on states to pre-clear their laws provides a level of protection that no longer exists. I, as a former election official, election attorney, having worked within the scope of Section 5 in Arizona, have found it to be quite burdensome, frankly, requiring the state to undergo approval of very minor technical changes at great expense that really were sort of somewhat perfunctory. Approval came, and I just haven't seen the state engaging in any kind of overt discriminatory behavior that would justify this serious breach of state sovereignty. So I think, while I understand the arguments for Section 5, certainly the arguments that existed in 1965 and maybe 1975 when Arizona became covered, I agree with the Chief Justice and the court that this no longer reflects what we have today in terms of discrimination. And discrimination is going to happen. It's just a question of how widespread and systemic is it, and is there an effective remedy to prevent it or discourage it? And I think we have that through an enforcement action under Section 2, an equal protection challenge under the 14th Amendment. There certainly are remedies available if any governmental actor engages in that type of behavior.
In fact, the Chief Justice, in his opinion, offered up a remedy, go back to Congress and get Congress to change the formula. Did Congress not at least consider that when it renewed the Voting Rights Act in 2006?
No, and in fact, as the Chief Justice points out, Congress arguably did the opposite by expanding the scope of coverage under Section 5 and raising the bar that states have to clear in order to get their voting laws and procedures pre-clear, which he found problematic, especially in light of a prior decision a few years ago where the court had sort of signaled to Congress that they had some concern about the continued viability of Section 5 of the Voting Rights Act. So although Congress can certainly go back and amend the coverage formula, that's going to be a difficult question as to what states should be covered, should be required to have their laws pre-cleared in advance. Have they engaged in behavior now? Is there discrimination that continues in a systemic and widespread and pervasive way that would justify that type of encroachment on state sovereignty? That's a difficult question that the court said the Congress really failed to debate in 2006 when it reauthorized the act.
Kanefield went on to discuss how the law affected the state's electoral process and how the effects could be different in the future. You mentioned that you were the state elections director probably about a decade ago. under Jan Brewer, who then was Secretary of State, now is Governor. Yes. Give us one or two examples of the types of issues that you faced in an effort to comply with the pre-clearance issues in the Voting Rights Act.
Well, it ranged. You know, if the state legislature changed one of the election laws to extend the period of time that early voting is allowed or shorten it, that's a significant change. There you could see why the state would need to show that it wasn't going to discriminate against any of the language minority groups in Arizona or leave them in a worse position than they would be had the law not passed. But it also came down to really minor changes, like if we were revising the form, the voter registration form, and adding an additional box or something that was very benign but necessary for administrative purposes or to make our election system more efficient. We would have to undergo this process of filling out a complex petition to ask the Department of Justice to pre-clear it. The burden was on us to justify why it would not have any kind of discriminatory impact on language minority groups in Arizona, and it was time-consuming. It was a 60-day process if we sought administrative pre-clearance through the Department of Justice, but it could take longer if the department needed more time or wanted more information.
Would we assume now with the Supreme Court's ruling that those issues go away, that it'll be smoother sailing for making changes in election law?
Yes, no doubt about that. From an election administration point of view, things will be much smoother. At this point, from the election officials' standpoint, they will be able to implement their changes in their procedures and practices on a much more expedited basis. It will free them up to do things that may help eliminate lines in polling places and allow them to expedite the counting of ballots after the election. And little things that take up a lot of time and need a lot of attention, but anything that distracts the election officials prior to the election prevents them from doing the kinds of things that make elections run much smoother.
Everyone watches these issues very closely because of politics, Republicans, Democrats, accusing one another of trying to manipulate the system. Whether it's true or not, the accusations are there pretty constantly. How does the law continue to prevent partisanship from creeping into the process, especially in a state such as Arizona where one party is in control of most of the state systems?
Well, there's always going to be partisanship in elections for obvious reasons. We hope that our officials, elected officials, stay within the parameters of the law to the extent that laws benefit one party or another. Those are permitted as long as they don't violate any provision of the United States or Arizona constitutions or any provision of state law. So there are remedies available if in case the line is crossed through either a federal or state court enforcement action. So I think with the competent election counsel that we have out in the state, along with very savvy candidates, political consultants, activists, and others, we have enough people to keep the system in check. We have mechanisms for challenging laws or procedures if they cross the line, and I don't think Section 5 is necessary anymore in Arizona.
You also serve as co-counsel to the Independent Redistricting Commission in Arizona, and there's litigation underway about that right now. How will the Supreme Court's ruling affect what's going on in court right now in relation to the drawing of legislative and congressional districts in the state?
It shouldn't have much of an impact on the case. Where that case is postured now is where a trial occurred in late March. We're waiting for a decision from the federal panel that heard the case. The issue in that case has to do with the population deviation among the districts. The general rule is you can have a slight deviation in population in legislative districts, but the deviation has to be justified by rational reasons. The primary reason offered by the Commission to justify the small deviations, and we're talking about deviations of under 10% between the largest and the smallest district, was compliance with the Voting Rights Act, because we had to make sure that no minority language group, including Hispanic voters, Native American voters in Arizona, were diminished in their ability to elect their candidate of choice. So that required that certain districts be drawn in a way to respect their ability to elect their chosen candidates. And we had to achieve preclearance from the United States Department of Justice or a federal court. We chose to go to the Department of Justice, but we had to achieve that preclearance before those districts could be used for the 2012 and subsequent elections. So the extent that the Voting Rights Act no longer applies because the Supreme Court has declared the coverage form unconstitutional, we see that as a prospective ruling at all times during the process under which the Commission was drawing the legislative map. Section 5 and the coverage formula under Section 4 were the law of the land, certainly the law governing Arizona. We achieved preclearance on our first submission from the Department of Justice, and that was, in our minds, sufficient justification for the small deviations that occurred in the districts. But we'll have to see. The court will, of course, may consider that ruling as it reaches its decision, or it may not.
So should the court rule that the deviations were too great and return the maps, if you will, to the state to be redrawn to meet the parameters of the law, what applies as far as the Voting Rights Act goes? Are we going forward from what the Supreme Court has ruled, so preclearance won't be necessary at the Justice Department level?
Well, that's a very good question, and those are issues that we as counsel for the Commission will have to consider very carefully. It may be issues that have to be dealt with in court or not, but at this point I don't have an answer for you, because obviously at the time these lines were drawn, Section 5 and the coverage formula under Section 4 were the law of the land. If the federal panel that is hearing this case decides differently or decides that the Commission needs to do something differently, then we'll have to see what the court has to say and look at the current state of the law and decide how best to move forward.
And then looking ahead a few years to the next round of redistricting, which would be after the 2020 census. So in 8 or so years, the Commission will be at this again. What will the federal law in terms of the Voting Rights Act be that applies then?
Well, we don't know at this point because, like I said, the Supreme Court invited Congress to revisit the formula, the coverage formula, if it wishes. So between now and then, the Congress may do that. It's not clear whether Arizona or any jurisdiction within Arizona would be covered. But assuming that Congress is not able to amend that formula or agree on what the scope of the coverage formula should be, and we are left with the state of the laws that exist at this moment, then we will not have a preclearance requirement when the next redistricting commission goes about drawing this congressional and statewide legislative maps.
But in that regard, if there's no congressional action and there's not a preclearance, the Commission still has to take a look at racial balance. Is that not correct?
That's correct. And so all that this means is that the burden will not be on the Commission to justify that the maps are non-discriminatory before they can be used, either through the Department of Justice or the federal court in Washington. It doesn't mean that the Commission or anyone else has license to discriminate against any minority group, and so that the Section 2 of the Voting Rights Act that implements the 15th Amendment will still have to be respected, and that those, of course, would be considerations that the Commission would make when it goes about drawing those maps, even for the next redistricting cycle.
Some Arizonans have said for years that the state should not have been under the federal preclearance requirement. Others say it still should be because of what they say are ongoing efforts to suppress voting. Here are the two sides in that argument. Do you have any sense that there's discrimination going on in the voting process in Arizona?
I would say there probably is some discrimination. There's some voter fraud. So I think we'll probably, as long as you have a partisan system like we have, there's going to be people trying to manipulate the system in all directions.
We still struggle with, discrimination and things like voter ID laws that just put on unnecessary barriers for not only Latino voters but everybody to stop them from a easiest path to voting in every election.
The Voting Rights Act is meant to minimize that or even eliminate it, and now a key part of it has been taken away. Will that lead to an increase in discrimination, do you think?
No, and actually this is not a key part of the Voting Rights Act. All of the protections that people think of when they think of the Voting Rights Act, guaranteeing access to the ballot, prohibiting discrimination, they remain intact. Nothing that was illegal yesterday is legal today. Basically what was removed was what was intended to be an extraordinary, temporary emergency measure aimed at a handful of states that were absolutely dead set against black voting participation. Unfortunately, those provisions expanded and almost became permanent even as the emergency receded.
What will be the recourse now that the Supreme Court has ruled invalidating the preclearance?
Well, the ruling states that Congress now has to figure out a formula to ensure that which states are covered under Section 5. So we are hopeful that Congress will find that formula as quickly as possible because it affects many states. The whole state of Arizona. It affects us, over 500,000 Latinos, tens of thousands of Native Americans. Potentially, this decision has opened possible discrimination against these voters.
Given the political makeup in Washington right now, the chances that Congress will act on this seem slim. What is the recourse, assuming no congressional action?
Yeah, we're optimistic that they will act, but we understand that currently there's a dysfunctional Congress right now in Washington, and where issues like immigration reform, where there's broad bipartisan support, there's 70% of Americans want a solution for that. They still have trouble in bringing that solution forward. So we are very hopeful, but we understand the dynamics of politics.
Arizona just enacted some election-related legislation, mostly having to do with early ballots and the early ballot mailing list. That presumably would have had to been sent to the Justice Department for preclearance, but now it won't?
That's right. The recent changes that Arizona made, we will not have to seek permission of the Justice Department to put those laws into effect. If people think that there are legal problems, and in fact I know that there are people who do think there are legal problems, they can take them to court just as before, and we may see them upheld or struck down.
We will be fighting the voter suppression ID laws that were passed here in Arizona. We're thinking about several measures, taking that to a lawsuit, to putting it as a referendum here in this state to ensure that we give the voters the opportunity to say if they agree with this law or they disagree with this law. And we think the large majority of voters will disagree with what the state legislature passed here in Arizona.
There are those who say that Arizona never should have been included in Section 5 of the Voting Rights Act to begin with. It was added in 1975 because there wasn't the kind of blatant discrimination in Arizona that we saw in other parts of the country, especially the South, against African Americans. What do you say in response to that?
No, I think Arizona, it was under Section 5 preview for a reason. That in 1975 because they failed to send out bilingual ballots to residents, voters that were part of the process that were registered. So from there on, we've seen attacks against voters and ensuring that they have barriers put up in front of them in casting a ballot. So we believe strongly that Arizona should be included in the future to ensure that no voter is discriminated, because we believe that if one voter is discriminated in the process, that's one voter too many.
You have argued in the past that Arizona never should have been a part of this from 1975 on, when it was added into the mix, that it was in there even perhaps by accident. Could you explain that?
Well, the original Section 5 was designed to go after Southern governments that really were going to do anything and everything they could to keep blacks from voting. In 1975, 5 years after the original provision was supposed to expire, but it did not, a number of other jurisdictions were added when language minorities were added to the law, and a very complex formula was put in place to bring these states into the law. One of those states was Arizona, which at the time had a Mexican-American governor. And Arizona never did anything nearly so brazen as the southern states did, but it was treated just like those southern states. It was subjected to incredibly intrusive federal regulation, and it was never released from that penalty box.
Voter turnout is a part of that larger formula that's been used. And voter turnout among minorities in Arizona is traditionally low, has been historically, and was arguably in the last presidential election last year. So how does that fit into the grander scheme of this? Should that be a kind of a trigger point for this?
I don't think voter turnout should be a trigger. Basically, the question is whether voter turnout is being suppressed by the government. And there's no evidence of that whatsoever here in Arizona. As Latino groups that are trying to get out the vote can tell you, it is really tough to get people to turn out to vote.
Voter turnout has always been an issue in the Latino community. The motivating factors sometimes are not there for our community to ensure that they vote in every election. I think we see some progress in the last 4-6 years as the Latino community grows and gets more acculturated with the process and understanding the process.
Longer versions of my interviews with all of tonight's guests are on our website, azweek.com. That's our program for Friday, June 28th, 2013. For Arizona Week, I'm Michael Chihak.
Production of Arizona Week is made possible in parts by a grant from the Stonewall Foundation and by the members of Arizona Public Media. Thank you for your continued support.